My cousin slapped my $1,300 phone into the pool and laughed. I gave him 47 days to fix it. He didn't. Now 20% of every paycheck he gets comes to me /. I want to start with the sound, because the sound is the thing I cannot stop hearing when I replay that afternoon. The specific flat slap of a hand against a phone and then the small splash that followed it, and the half second of silence before the laughter started. My cousin Devin thought it was the funniest thing that had happened all summer. He stood at the edge of the pool with his hands still extended from the follow-through, laughing with the full-body ease of someone who had just done something hilarious and was waiting for the room to catch up to the joke. The room was my aunt's backyard. The audience was 11 members of my family. And the thing at the bottom of the pool, catching the light through 4 feet of water, was my $1,300 iPhone that I had owned for 19 days. I stood at the edge and I looked at it and I felt something arrive in me that I have since learned to recognize as the specific sensation of a situation that is going to require a decision, and that the decision I make in the next 30 seconds is going to determine whether this moment becomes a story I tell as a funny memory or a story I tell as the reason I spent 4 months in a legal process with a member of my own family. I did not know in that moment which version it was going to be. I found out when I asked Devin to replace it and he said, still laughing, still with the ease of someone who found the whole thing genuinely amusing, "It's just a phone, bro. Dry it out." I need to tell you about Devin before I tell you about the court, because understanding Devin is understanding the 47 days between the pool and the filing, which were the 47 days I spent trying to resolve this without the legal system and which produced nothing except a progressively clearer picture of who I was dealing with. Devin is my mother's sister's son. We are the same age, 28, which means we grew up at every family gathering from birth to now, which means I know him with the specific completeness of someone you have watched across childhood and adolescence and the early years of adulthood. I know his laugh. I know the specific way he processes accountability, which is to locate the framing in which the accountability does not apply to him and to hold that framing with remarkable consistency regardless of what evidence is presented against it. I had watched him do this across 28 years of small and medium situations. The pool was the first large one. The response was exactly what the previous 28 years had prepared me to expect and that I had hoped, against the evidence, would be different because the stakes were different. The phone had been at the surface of my back pocket. I had been sitting on the pool steps with my feet in the water, not swimming, specifically not swimming, keeping my phone dry with the specific intentionally of someone who had spent $1,300 19 days ago and was not casual about the proximity of that investment to large bodies of water. Devin had come up behind me and had thought it would be funny to slap the phone from my pocket. Not push me in. Not a prank involving me. Just the phone. He had assessed the situation and decided the specific target of a $1,300 device was the comedic choice. He had been right that it would get a reaction. He had miscalculated what kind. The phone was in the water for approximately 40 seconds before I got to it. 40 seconds at the bottom of a chlorinated pool is not a survivable experience for a smartphone regardless of water resistance ratings, and this phone's water resistance rating had been tested and found to have limitations by a drop I had experienced 3 weeks before purchasing it, which was why I had spent $1,300 on a replacement rather than a repair. The screen was black when I pulled it out. I pressed the button. Nothing. I pressed it again. Nothing. I stood at the pool's edge with a dead phone in my hand and water running down my arm and Devin still laughing, and I made a decision about the next 30 seconds that I want to tell you about honestly because the decision was not entirely clean. I did not react. I want to be precise about what I mean by that. I did not scream or cry or make the scene that the situation might have justified. I was aware that there were 11 people watching and that how I responded in the next 30 seconds was going to establish the frame for everything that followed. If I lost composure, the story became about my reaction. If I was calm, the story stayed about the phone at the bottom of the pool. I chose calm not because I was calm but because calm was strategically correct. I said, evenly, to Devin, "You need to replace this," he said, still with the laughter in his voice. "Come on, it's probably fine." I said it was not fine. He said, "It's water resistant." I said I was aware of the rating and that the phone was not responding. He looked at it. He looked at me. He said, "Dry it out, it'll be fine by tomorrow." And then he jumped into the pool. That was the first conversation. It lasted approximately 45 seconds and it told me everything I needed to know about the 47 days that were coming, but I was not yet ready to accept what it was telling me. I spent the following week pursuing the resolution I still believed was available through ordinary conversation. I texted Devin the next day with a photo of the black screen and the information that the phone was not recoverable. He said that was rough. I said I needed him to replace it. He said he did not have $1,300. I said I was not asking for cash immediately, I was asking for a commitment to replace what he had destroyed and a plan for how he intended to do it. He said he would figure something out. Figure something out is the specific language of someone who has decided that time is their strategy, that if they provide enough vague forward-looking statements the situation will eventually be absorbed by the passage of time and the other party's desire to avoid conflict. I recognized the strategy. I had watched him use it for 28 years in smaller situations. I gave him a week. The week produced nothing except 3 more conversations that followed the exact pattern of the first one, with the specific consistency of a script. He did not have the money right now. He would figure it out. It was an accident. It was a joke. He had not meant for the phone to be damaged. I want to address that last point directly because it became his primary position and it is worth examining clearly. He had not meant for the phone to be permanently damaged. That is probably true. What he had meant was to knock a $1,300 electronic device into a pool of water, which is an action whose probable consequences are not mysterious. The intention to cause permanent damage and the intention to perform an action whose probable consequence is permanent damage are different things, but the difference between them does not change the outcome for the person holding a dead phone. My mother heard about it at the second family gathering after the pool incident. She pulled me aside and said, with the specific careful tone of someone who loves you and is also managing a family system, "Are you really going to make this into a whole thing?" I said I was going to make it into exactly the thing it was, which was a situation where someone had destroyed my property and needed to replace it. She said it was Deven. I said I was aware it was Deven. She said it would cause drama. I said the drama had been caused by the person who slapped a $1,300 phone into a pool and had subsequently declined to replace it, and that my pursuit of replacement was not the source of the drama but the response to it. She did not disagree with me. She also did not help me. By day 40 I had documentation. I had the text conversations, screenshotted and dated. I had the receipt for the original phone purchase, 19 days before the incident. I had the assessment from the phone repair shop confirming the phone was not repairable and the cause was water damage. I had the photo of the black screen with a timestamp. I had a record of every conversation in which Deven had acknowledged the incident, declined immediate payment, and provided vague future commitments that had not been honored. I had built, without entirely planning to build it, a small claims case. And on day 40 I made the decision I had been moving toward since the pool, which was to stop waiting for Deven to do the right thing and to use the mechanism that existed specifically for situations where the right thing was not forthcoming voluntarily. I filed in small claims court on day 47. The filing fee was small. The process was more straightforward than I had expected. I filed for the cost of the phone, $1,300, plus the filing fee, plus a documentation of the specific chain of events. I submitted the documentation I had accumulated. I requested a hearing date. The court provided one. I sent Deven the notification. He called me within 2 hours of receiving it. The call was the first time across 47 days that his voice had lost the easy, slightly amused quality it had carried through every previous conversation. He said I was serious. I said I had been serious since day one and that the filing was evidence that I remained serious. He said I was going to take my own cousin to court over a phone. I said I was going to use the legal mechanism available to me to recover the cost of property he had destroyed and declined to replace. He said this was going to BLW up the family. I said the situation had been created by the pool and sustained by the 47 days of non-resolution that followed it and that the filing was my response to that situation, not its cause. He said I was being ridiculous. I said I would see him in court. And then I did something I had not planned to do. Not strategically. Not as part of any plan. I said, before I ended the call, that if he wanted to resolve this before the hearing date he knew what resolution looked like and I was available for that conversation any time before we sat in front of a judge. He was quiet for a moment. Then he said he would think about it. I said okay. I ended the call and I sat with what I had just done and I felt, for the first time in 47 days, that the situation was in a frame I actually had some control over. The hearing was scheduled for 6 weeks out. In those 6 weeks Deven did not call me back with a resolution. He did not reach out with a payment plan. He did not send a partial payment as a gesture of good faith. What he did was tell the family, in the specific way of someone who understood that the social pressure of family opinion was his best remaining resource, that I had taken him to court. He told it without the pool or the 47 days or the documentation. He told it as a story about a cousin who had filed legal papers over a phone. The response from several family members was what he had hoped for, which was a version of what my mother had said, which was that I was making this into a whole thing. I went to the hearing with my documentation in a folder organized by date. Deven came with the easy manner of someone who had decided that his version of events was more compelling than mine and who had not understood that small claims court is not interested in versions. It is interested in evidence. The judge was interested in the receipt, the repair assessment, the text messages, the timeline. She was interested in these things for approximately 12 minutes. She ruled in my favor. $1,300 plus filing costs. Payable within 30 days. Deven did not pay within 30 days. That decision, the decision to ignore a court order, was the one that moved this from the story of a pool and a phone into the story of 20% of his paycheck. When someone does not pay a small claims judgment within the ordered timeframe, the legal system provides a mechanism for collection that does not require the person who won the judgment to continue asking nicely. I learned about wage garnishment in the way I had learned about small claims filing, which was by researching what options were available to me and then using them. The process of obtaining a wage garnishment order required additional filing and a return to court, but the documentation I already had made it straightforward. I filed for garnishment. The court approved it. Deven's employer was notified. 20% of his paycheck began coming to me. Deven called me the day after his first garnished paycheck. The easy manner was entirely gone. He was not laughing. He said I had gone too far. I said the judge had ordered payment 30 days after the hearing, that 30 days had passed without payment, and that I had used the legal mechanism available for exactly this situation. He said I was destroying his finances. I said $1,300 plus fees was the amount the court had determined he owed, that the payment structure of 20% per check was the standard garnishment rate, and that the total amount would be recovered in the number of paychecks that math required. He said I could have just called him. I said I had called him for 47 days before filing. He said the garnishment was humting. I said the phone at the bottom of the pool had been $1,000 loss and a month and a half of conversation that had produced nothing. He said this was not how family treated each other. I said I had given him 47 days and a court deadline to treat me like family before I used the court's collection process. He said he could not believe I was doing this. I said I could not believe it had gotten here either. I meant that. I genuinely meant that. I want to be honest about something that I have been sitting with since the garnishment began, because this story requires the same honesty that every story I have told requires, which is the kind that does not let me off every hook just because I was the one who was wrong first. I was wrong first. The phone in the pool was real. The 47 days were real. The court order was legitimate and the garnishment was a legal and proportionate response to a court order being ignored. All of that is true. And I have also been thinking about the specific choice I made on day 47 to file rather than escalate to one more direct conversation, and whether that conversation might have produced something different, and whether I will ever fully know the answer to that question. I had a reason for not making that call, which was that 47 days of calls had produced the specific result of 47 days of calls, which was nothing. But the specific call I did not make on day 47 was not the same as the previous 46 calls. The previous calls had been requests for voluntary resolution. The call I did not make on day 47 would have been a clear and direct statement that I was about to file and that filing was the alternative to immediate resolution. I had made a version of that statement on the phone after the filing notification. I had not made it before the filing. The question of whether making it before would have produced a different outcome is one I cannot answer and have to sit with. I am not saying I should not have filed. I am saying I want to be honest about the choices in this story that were mine and what I knew when I made them. That is what this kind of storytelling requires. The family response to the garnishment was louder than the response to the filing. My aunt, Deven's mother, called me. The call was not pleasant. She said things about family loyalty and proportion, and the specific word she used was vindictive, which I have been thinking about since she said it, with the specific attention you give to a word when you want to examine whether it is accurate. Vindictive implies a motivation beyond the stated one, implies that the legal process was being used not to recover a loss but to cause damage in excess of what the loss required. I have examined that honestly. The amount I am recovering is the amount the court determined I was owed. The method is the standard legal method for recovering a court-ordered judgment. The proportionality is not mine. It is the court's. Whether there was a part of me that had satisfaction in the garnishment beyond the satisfaction of recovering what I was owed is a question I want to answer honestly rather than defensively. There was. I want to say that clearly. After 47 days of the easy manner and the vague forward-looking statements and the figure-it-out language, there was a specific satisfaction in watching the legal mechanism work with the impartiality and consistency that the 47 conversations had not produced. That satisfaction was real. Whether it was vindictive is a question of degree that I am not entirely certain how to answer. What I can say is that the satisfaction was not my motivation. The recovery of $1,300 was my motivation. The satisfaction was a secondary experience I am being honest about rather than pretending did not exist. Priya, my cousin on my father's side who had no involvement in the situation, called me 3 weeks into the garnishment. She was not calling to weigh in on whether I had been right or wrong. She was calling because she had been at the pool that afternoon and she had watched the whole thing, and she said she had been thinking about it since the judgment. She said she had watched Deven knock the phone in and she had seen my face and she had expected me to BLW up, and when I had not BLWN up she had understood that I was thinking rather than reacting, and that she had known from that moment that the situation was going to go somewhere. She said she thought I had been right to file. She said she also thought the 47 days had been longer than they needed to be, and that the clearest and most honest thing I could have done was tell Deven on day one, in front of the family, exactly what the situation was and exactly what the consequence of non-resolution would be. She said doing it in front of the family would have been uncomfortable and might have produced the resolution without the court, and would certainly have removed the ability of anyone to claim later that they had not known what was happening. I thought about that. I think she was right. The decision to handle it privately across 47 days had been partially about giving Deven the chance to do the right thing without public pressure, which was a generous impulse, and partially about my own discomfort with being the person who made a scene at a family gathering, which was a less generous impulse dressed in generous language. Deven and I have not spoken since the garnishment call. At the most recent family gathering we were in the same backyard and we did not speak, and the family navigated around us with the careful efficiency of people managing an acknowledged situation by not acknowledging it. My aunt looked at me once across the yard with an expression I did not try to interpret. My mother stood beside me for a while and did not say anything about it, which was its own form of support, the specific support of a person who has accepted that a situation has arrived at its destination and that further commentary is not useful. The garnishment is ongoing. At the current rate it will be complete in several more paychecks. When it is complete the court order will be satisfied and the legal process will be finished. What will not be finished is the specific reconfiguration of a family relationship that has been in process since the flat sound of a hand on a phone and the small splash that followed it. Deven and I grew up at every family gathering from birth. That history is real. What it is going forward is something I do not yet know and cannot predict, because it depends on things that have not yet happened, specifically on whether Deven is capable of arriving at a place where he understands what the 47 days in the court and the garnishment were actually about, which was not the phone and was not the $1,300. It was the specific quality of a relationship in which one person consistently locates the framing in which they bear no accountability and holds it regardless of evidence, and the specific moment when the other person stops accepting that framing and finds a mechanism that does not require acceptance. The phone was the occasion. The accountability was the point. I have the judgment. I am collecting it. 20% of his paycheck, arriving with the impartiality of a court order, does not require him to accept the framing or acknowledge the point or arrive at any particular understanding. It simply arrives. And it will continue to arrive until the number is satisfied, at which point the legal chapter closes and whatever comes after it begins. I do not know what comes after it. I know that I stood at a pool's edge with a dead phone in my hand and I made a decision about the next 30 seconds that set a direction, and I followed that direction with the documentation and the filing and the hearing and the garnishment, and the direction led here. Here is a family that is navigating around something. Here is a cousin who is not speaking to me. Here is a judgment being collected 20% at a time. Here is a $1,300 phone that is still at the bottom of a metaphorical pool because nothing that happened after it went and brought it back. You cannot garnish what was actually lost. You can only recover the number the court assigns to it. And the number and the loss are never exactly the same thing. That is the part no filing fee covers. And no judgment fixes.